Hello people, how are you? What's up? I hope you all are doing extremely amazing. People, today we're going to begin off with the most important subchapters under Companies Act, and that is Board of Directors and KMP in your corporate and economic law exams. Definitely 7 to 14 marks worth of questions are asked in your exam in every attempt. Right people? So once you are done with this lecture, it is my guarantee that you will be thorough with every single concept under Board of Directors and KMP. Okay, people? So, this lecture will be of 1.5 hours, 2 hours. So, make sure that you utilize it as much as possible. Okay? Very easily, you can score 7 to 14 marks just from this sub-chapter. Okay, people? So, without wasting any time, let's get started with our new sub-chapter, that is Board of Directors and KMP. So people, in this, how many topics are we going to cover? Number 1 is people, number of directors we are going to cover. First topic, that is section 149. Next is people, we're going to understand the concept of independent directors. After that, appointment of directors, section 152. Then people, appointment of additional alternate nominee directors and how casual vacancy is filled in the board of directors also we are going to understand. Then people, appointment of directors elected by small shareholders, that is section 151. Then people, we are going to understand disqualification of director, section 164, resignation, section 168, and then removal of director under section 169. It is my guarantee that by the end of this lecture you will be thorough with every single section also. Okay, usually students have this problem in remembering the sections. After watching this lecture, you will not have the same problem again, people, right? And then people are going to understand when is the director's office vacated, that is section 167. Then comes the next topic, that is KMP. So payment of remuneration of KMP, that is section 197. After that, people are going to understand what are the powers of the board of directors, section 179. Then people are going to understand what are the restrictions on the powers of board of directors, that is section 180. Then people are going to understand how should a director disclose his interest whenever he is entering into a transaction where he is in any manner interested or related to the person, that is section 184, disclosure of interest. Then people are going to understand related party transaction, that is section 188. After that, people, interested director, how are you going to treat the interested director? What are the compliance requirements of interested director? Then people, compensation for loss of office. If a director's office is vacated, if a director is removed, are we going to pay him remuneration or not? We're going to understand. Then people, appointment of KMP. Which companies are required to appoint key managerial personnel? That is governed by which section? Section 203, people. Sir, there are so many topics to study. How is it possible to complete this in 1.5 to 2 hours? People, you don't have to worry, because in this lecture, we're going to revise using the mind maps. Right, people? Chalo. So, without wasting any time, let's get started with our first topic, that is number of directors. So, people, women director. Let's start with women director. So, to which companies women directors applicable? To top 1,000 listed companies, appointment of women directors mandatory, and to every unlisted public companies having a paid-up capital of 100 CR or more or turnover of 300 CR or more have to appoint women director. Okay. So if a company is newly incorporated and then this rule comes, the company has got how many months to comply with this rule? They have got 180 days to comply with this rule. And then comes people, if a woman director's office is vacant, within how much time the vacated office should be filled? As early as possible. Next is very, very important. Less than the immediate board meeting or 3 months from the vacancy. So, woman director's office should be filled at the most earliest date. Which are the two earliest dates? Number 1 is next board meeting or 3 months. Whichever is earlier, in this period, women director's office should be filled in case of vacancy. So office should be filled before the next board meeting or 3 months, whichever is earlier. Very simple. Now comes resident director. Okay. So what is the purpose of resident director? Every company should have at least one resident director who has stayed in India for a period of not less than 182 days. Sir, why is this provision made? So that we would not want any foreign company where everyone is foreigner. And in case that company involves into fraud, who are we going to make responsible? Nobody is resident director over there. Yes or no, people? So every company in India should have at least one resident director who has stayed in India for a period not less than 182 days. Okay. Now, people, woman director section is section 149 subsection 1. Ladies first. So first means 149 subsection 1. And then comes people resident director. Means Indian. Are you going to find auto in foreign countries? No. Only in India you are going to find autos. Sir, why did you mention auto? Because auto has got 3 wheels. That means 149 subsection 3. The moment you hear resident director, you have to visualize auto. Why? Because auto has got 3 wheels and auto is only you will find in India. Yes or no, people? Perfect. Next is independent director. So independent director. So independent director should not be a independent director should be a non-executive. He should not be continuously working in a company. Next is he should not be a managing director. He should not be a whole-time director, and he should not be a nominee director. He should only be a non-executive director. Plus, he should not have any material or pecuniary relationship with the company, its holding company, its subsidiary company. Okay. Sir, can he receive data remuneration? Yes, he can receive data remuneration. Sir, can he enter into transaction with the company? Yes, provided the transaction is not more than 10% of his gross total income. If I am an independent director, if I want to purchase flight tickets from Indigo Airlines, does that mean that I cannot become an independent director of Indigo Airlines just because I have purchased flight tickets? No. So I can become an independent provided I should not enter into a transaction with the company more than 10% of my gross total income. Okay. Now next, to which companies independent directors are applicable? All listed companies must have at least 1/3 of the total directors as independent directors. If it is 2/3 of 3, if the number is coming in point, it should be rounded off to 1. Okay. For example, 2.3. It means 3 independent directors should be appointed in a company. Right, people? So all listed companies should appoint independent director. How many? 1/3 of the total number of directors should be independent. Next is people, unlisted public companies with a paid-up capital of 100 crore or more, paid-up capital of 10 crore or more, turnover of 100 crore or more, and outstanding loans and borrowings 50 crore or more. They should have at least 2 independent directors. Again, all listed companies should have at least 1/3 of total directors as independent director. And next is every public company having a paid-up capital of 10 crore or more, turnover of 100 crore or more, outstanding loans, borrowings, deposits is 50 crore or more. They have to appoint 1? No. They have to appoint 2 independent directors. Very easy, people. Okay. So, what is the term of independent director? His term should be maximum 5 years. Sir, can he be reappointed? Yes, he can be reappointed by special resolution, but it must be disclosed in the board report. Next is after 2 consecutive tenure. What is the cooling off period? What is the meaning of cooling off period? That means he cannot be associated with the company for this period. What is the cooling off period, people? He must wait for at least 3 years and he must not be associated with the company. After that only he can be reappointed. Okay. And is independent director liable to retire by rotation? No. He is not liable to retire by rotation. Next is, if he is appointed for a period less than 5 years, would it be counted as 1 term? Yes, it will be counted as 1 term. Next is people. So, Meetings. What is the meeting requirements of independent directors? Independent directors should have at least one meeting in every year where non-independent directors are not included. So all the independent directors should have one meeting in each year without inclusion of non-independent directors. Okay. So, sir, are independent directors liable for any fraud? No, they are not liable for any frauds. They are only liable for the acts committed with their knowledge, consent and connivance. If they could have stopped it and they did not, they will be held responsible. Okay. Next is next. Yes, people. So, what is the section of independent director? Section 149, subsection 4. What is the section of woman director? Section 149, subsection 1. Ladies first. What is the section of resident director? Three-wheeler auto means India. So, 149, subsection 3 is resident director. Very easy, people. Next. So, what is the eligibility criteria of independent director? When can I be called as an independent director of a company? First of all, people, I should be a person of integrity and expertise. I should be a man of my word. Yes or no? Next is, I should not be a promoter. I should not be related to the promoter of the company, its associate company, its holding company, its subsidiary company. Okay. And I should have some basic skills in finance, law, management, marketing, etc. Okay. Now, sir, can independent director have voting? Can he hold shares? People, voting power restrictions. Independent director cannot hold 2% or more of the total company's voting power along with his relatives. That means what? If I want to be an independent director, I should hold shares less than 2% of the total voting power of the company. Very easy. Now next, pecuniary independence, which means what? I should not have any financial relationship with the company beyond my director remuneration, and I should not enter into any transaction that is more than 10% of my total income. In current year also, in the preceding 2 years also, I should not enter into any transaction. Yes or no, people? Okay. Now next, independent directors. If I am an independent director, I along with my relatives should not purchase shares or securities of the company, its holding company, its subsidiary company, its associate company for a value not more than 50 lakh rupees or 2% of paid share capital, whichever is less. This should be my limit. And next is, I should not be indebted to the company, its holding, associate, subsidiary for more than 50 lakh rupees. I should not provide any guarantee to the company, its holding, subsidiary, associate more than 50 lakh rupees. I should not. Next is, I should not have any pecuniary transaction with the company, holding, subsidiary, associate more than 2% or more gross turnover or total income, whichever is less. Yes or no, people? Very easy. Okay. Now next, this is very, very important. Employment restrictions. That means what, people? I should not be the director, or my relatives should not be a director in a company. Next is, I or my relatives should not be employees, KMPs, proprietors or professional service providers to the company. Next is, I along with my relatives should never be appointed as auditor, company secretary, cost auditor or any legal consultancy firm in the last 3 years. Okay, exception is if my relative is appointed as a normal position, ordinary position in a company, then I can be still appointed as an independent director. Yes or no, people? And next, this is gross 10% of the gross turnover of the firm, which means what? The auditors, company secretaries, cost auditors, legal consultancy firm should not provide services more than gross 10% of the gross turnover of the firm in the last 3 years. Okay. Now, people, this is very, very important. What is this? So, people, if an NPO if an NPO, independent director, cannot be the CEO or director of an NPO of that NPO which receives more than 25% of the total donation from a company in which I am an independent director, or I am holding more than 2% of that NPO's voting power, I cannot be held independent director. Yes or no, people? Perfect. So these are the eligibility criteria of independent director. What is the section? Section 149 subsection 6 talks about eligibility criteria. Yes or no, people? Perfect. Now let's come to first director. First director. So the moment a company is incorporated, and there is no provision with respect to how the directors will be appointed, the subscribers become the first directors in the company. Subscribers who sign the memorandum of association, who sign the articles of association, they become the first directors of the company. And it applies to all public and private companies. If it's the case of OPC, then sole member will become the first director. So basically, the why is this provision made? So that there should be someone who should be initially held responsible for starting the company's operation until final appointments of directors are made. Okay. Now next, appointment. How are the directors appointed at the AGM? So a person to be appointed as a director in the AGM, he should provide his consent to act as director in which form? DIR 2. Within how many days? Within 30 days. If it's case of IFSC company, it is 60 days. Okay, government company, it is exemption. Now, articles may provide that all the directors must retire by rotation. Articles may provide that all the directors must retire by rotation. If nothing is mentioned, 2/3 of the total directors must retire by rotation. Yes or no, people? And among those 2/3 of members, 1/3 of the total directors liable to retire by rotation must retire at the every AGM. Okay. Let's say, people, I'll give you an example. This is A, this is B, A, B, C, D, E, F. How many directors are there, people, total? 6 directors are there. If nothing is mentioned in the articles of association, then 2/3 of directors will retire by rotation. Yes or no, people? So 1, 2, 3, 4, 5, 6. So 2/3 of 6. This is 2. So 4 directors are liable to retire by rotation. 2 will be permanent. Yes or no? 4 will be liable to retire by rotation. Now, not every year these 4 will retire. Among these 4 people, 1/3 of 4 are liable to retire by rotation at every annual general meeting. So this is the provision. So 4 by 3 is something, will be 1 point something, 1.2 or 3. That means it is 2. So at every annual general meeting, 2 directors are liable to retire by rotation at every AGM. Otherwise, to which directors retirement rotation are applicable? To 4 directors. Yes or no, people? Among those 4 directors, 1/3 will retire at every annual general meeting. Very easy. Now, sir, how are you going to calculate who will retire first? The longest serving director will retire first. If both directors are appointed at the same time, then members will choose which one would retire at the AGM. Yes or no, people? Next is filling vacancy. If the retiring director's office is vacated, if I am supposed to be retired at this AGM, now my office is vacated. Now nobody is there in my position. Now company has to fill this vacancy. If the company has not filled this vacancy in the annual general meeting because of some issues, and then the meeting has been postponed, the meeting has been adjourned to the next date, and on the next day also nobody was appointed, then I will be deemed to be reappointed at the adjourned general meeting. Yes or no? Now, in which scenarios I will not be deemed to be appointed as the director? Let's understand. Number one is, people, first of all, shareholders have told that I should not be reappointed again. Number one could be that scenario. Number two is, I myself have expressed my unwillingness to act as a director. Next is, if I am disqualified or I am qualified. What is the meaning of qualified? I have been clearly told that I cannot act as a director because of some problem, moral turpitude, conviction, something. Next is, special or ordinary resolution is required, which couldn't be passed. In these scenarios, I could not be reappointed. In these scenarios, I would not be deemed to be reappointed at the AGM. Yes or no, people? Perfect. This is appointment of directors at general meeting. Okay. Now let's talk about additional director. Additional director. So, additional director, what is the section of additional director? Section 161, subsection 1. So, who can be appointed as additional director? Any person except one person cannot be ever appointed as an additional director. Who is that one person? If shareholders have clearly denied a person from acting as a director, that person can never be appointed as an additional director by the board. Yes or no, people? So, a person, any person except someone who failed to get elected as director in the general meeting, or company should follow articles of association should to appoint an additional director. Yes or no? Next, what is the tenure of additional director? Tenure will be until the next annual general meeting, or if the annual general meeting has not been held, then last date at which annual general meeting should have been held, whichever is earlier. So if I am appointed as an additional director by the board of directors, so my tenure will be until the AGM, because members will only appoint me as a director. Yes or no? Until then I am holding a temporary position. So AGM, in AGM members will appoint me as a director. Yes or no? If AGM was not held, in that case the last date on which AGM should have been held, that will be my tenure, whichever is earlier. Okay. Now, if AGM was not held, I have to vacate my office immediately. Then, people, is it applicable to private companies? Yes. What is the compliance requirement? We all know, whenever director is appointed, DIR 12 is filed, and along with DIR 12, attachments are attached. What are the attachments? Number one is board resolution. Number two is consent to act as director in which form? DIR 2. And number three is KYC should be done and disclosure of interest. Am I holding directorship in any other company? I have to disclose it upfront only. Okay. So this is section 161, subsection 1. Now next is, people, alternate director. Sir, what is the meaning of alternate director? Let's understand. Any person appointed to act on behalf of a director, and because that director is not in India for a period of more than 3 months, then on behalf, supposing if I am the original director, I am not in India for a period more than 3 months. In my place, somebody else can take place of my position until I return to India or my original tenure. Yes or no, people? So if I am absent from India for a period more than 3 months, a person in my place can be appointed. Now this is called as alternate. Now let's understand how will the alternate will be appointed. So meaning is, a person appointed to act on behalf of a director who is absent from India for a period more than 3 months. Now next, who can be, when can the alternate director be appointed? If AOA allows alternate director, then only alternate director will be appointed, or in the general meeting alternate director will be appointed. Okay. Now next, who cannot be appointed as alternate director? Two people can never be appointed as an alternate director. One is the person who is already an alternate director in a company. A, B, C. C is absent. So can B be appointed as an alternate director? No. This is the second. Now, first one. If on C's place, D is appointed as an alternate director. Now the question is, if tomorrow A goes out of India, can D be appointed as an alternate director for A? No, because he is already an alternate director of C. Same logic, people. Next is method of appointment. In board resolution, alternate director can be appointed. Board resolution will also include resolution by circulation, where physical board meeting is not held, it's only on circulation type. Okay, we're going to understand this. Next is, when will the tenure of alternate director end? When the original director dies. If I die, then the person who was appointed in my place, his tenure will also end. Or if I vacate the office, original director vacates the office, then the alternate director's tenure will also end. Or the moment I again return to India, then the alternate tenure will end. Very easy. Now, tenure shall not exceed the original director's tenure. Yes or no, people? Next is automatic reappointment. So, an alternate director will never be again automatically reappointed. Yes or no, people? For example, let's say I am the original director. Okay. So, in the AGM, nobody was reappointed in my place. So, if I am not falling under those exceptions of returning director, I will be deemed to be reappointed. But the problem is, in my place, somebody else is there. That means the person who was an alternate director will never be reappointed. Yes or no, people? And next is, if I am an independent director, if a person is appointed in my place, that person should also be an independent director. Yes or no, people? Now, directorship tenure counts. So if I am an alternate in 10 companies and the limit is 20, this 10 companies will also be counted. Yes or no? Very easy. Okay. Okay. So people, next is, who can appoint alternator? Board of directors can appoint alternator. Shareholders can never appoint alternator. Sir, just now you told that shareholders appoint alternators. People, over here, the question is, can a company appoint an alternate director in the first place? Now, this approval is given by shareholders or articles of association. Now, who is supposed to be appointed as alternator? Now, this shareholders can never decide. It is decided by the board. Always remember this. Okay. Again, I will tell you. Question number 1 is, can a company appoint alternate director? Now, who will tell this? Either articles of association will approve this or shareholders may approve it. Yes or no? Now, who will be appointed as alternate director? Now, this shareholders cannot decide. This board will decide. Yes or no, people? Very easy. Chalo. Now, let's come to the nominee director concept. Yes. What is section for nominee director? Section 161 subsection 3. What is section for additional director? 161 subsection 1. What is section for alternate director? Section 161 subsection 2. What is the section for nominee director? Section 161 subsection 3. Okay. Who is nominee director? If Lenskart has taken a loan from HDFC Bank for 100 crores, HDFC Bank may appoint a director in Lenskart so that Lenskart will utilize the 100 crore rupees in a wise manner. So for supervision purpose, for security purpose, the creditor can appoint a director in a company. So this is one of the reasons where nominee director can be appointed. So nominee director are appointed by the institution, government, or by an agreement to represent the interest of the HDFC Bank in Lenskart. So is it allowed everywhere? If AOA permits, it is allowed. Then rights and powers. Nominee directors are not liable to retire by rotation. Next is they hold office until and unless HDFC Bank says. If HDFC Bank asks them to resign, they have to resign. So nominee directors are just the puppets of the nominating agency. Okay. Perfect. Now let's come to the next topic, that is casual vacancy. Casual vacancy. So what is the meaning of casual vacancy? If a director is vacated before his normal expiry of his term, it is called as casual vacancy. Now who fills the casual vacancy? Board of directors fill the casual vacancy. Are members' approval required? Yes, members' approval are required in the general meeting to fill the casual vacancy. Now, until what is the period until when the person who fills the casual vacancy holds the office? Until the original director's term ends. Until then, he can serve as a director. Yes or no, people? And next is, if vacancy is caused by the board of directors, it is not filled by the board of directors, because that was a mistake of the board of directors. In that case, shareholders will fill the casual vacancy. This is not important, people. Okay. Chalo. Next is director elected by small shareholder. Now, what is the section of directors elected by small shareholder? Section 151. Okay. Now, what is the definition of small shareholder director? So shareholders who are holding less than 20,000 value of shares, it can be equity or it can be preference. Both are counted. They can appoint small shareholder director. Yes or no, people? So who are, first of all, small shareholder? The one who hold shares less than the value of 20,000 rupees. They are called as small shareholder. Remember, people, when we were discussing SEBI regulations, retail individual investors, okay, I just mix up the concept. For retail individual investor, it is 2 lakh rupees. For small shareholder under company's hand, it is 20,000 rupees. So who are small shareholder? The ones who hold shares for a value less than 20,000 rupees. And this will include equity shares. This will also include preference shares. Okay. Now, so who elects the small shareholder director? So listed companies can elect small shareholder director. When can they elect small shareholder director? When they receive notice from at least how many number of shareholders? At least 1,000 shareholders or 1/10 of the total small shareholders, whichever is less. So if notice is given by at least 1,000 small shareholder or the shareholders at least 1/10 of the total number of small shareholder. If there are 100 small shareholder, if 10 small shareholder give a notice that we want small shareholder director, then listed companies can elect small shareholder director. Okay. Company can also voluntarily appoint small shareholder director without the notice given by the small shareholders. Yes or no, people? Now, notice of intention to propose a candidate. So basically, small shareholder submits a signed notice. How many days before general meeting? 14 days before general meeting, small shareholder submits a written notice. Okay. They include their shareholder details. Next is proposed director details along with his name, address, shares held and folio number. Okay. Now next, what is the statement now proposed by the small shareholder director? Number 1, he should mention his DIN. He should mention that he is not disqualified. And number 3, he should give his consent to act as a small shareholder director. Okay. Now, the moment his tenure ends as a small shareholder director, he should not be associated with the company in any capacity. For how long? For 3 years. Now, vacation of office. When will small shareholder director's office will be vacated? If he ceases to be a small shareholder director. Number 2, if he incurs in disqualification. Number 3, his office is vacated, or he ceases to be independent. Okay. Now next, can small shareholder director be removed? Yes, he can be removed via ordinary resolution in the general meeting. Okay. Now what is the tenure? Tenure is maximum 3 consecutive years. He is not liable to retire by rotation. Sir, are independent directors liable to retire by rotation? No. So independent director, small shareholder director are not liable to retire by rotation. So he is also not eligible for reappointment. Yes or no, people? Okay. So we are done with all the points. Okay. Now what is the limit on number of directorship in which small shareholder can hold? Maximum he can be a small shareholder in 2 companies. He cannot be appointed in a competitive or conflicting business. Sir, can a person be appointed as a small shareholder in Amazon and Flipkart? No. Both are competing business. Swiggy, Zomato? No. Swiggy and Bata? Yes. Both are unrelated. Swiggy, Bata or Godrej? No. Maximum limit is 2. Okay. Now next, what is the disqualification for appointment of directors? Section 164. This is very, very interesting, people. What are the general disqualification? First of all, Companies Act puts a limit on number of companies in which a director can be a director. Maximum it is 20 companies. If a director is already in 20 companies, can he be appointed as again a director? No. So over here, section 165 talks about the limits under which a director can hold his directorship in company. So maximum limit is 20. If he crosses, he is disqualified. Next is, people, non-compliance under section 152 subsection 3. Sir, what is section 152 subsection 3 talks about? It talks about failing to file consent in form DR2. If he has not filed his declaration, that he is not disqualified, or he has done non-compliance. In that case, he is disqualified from acting as a director. Okay. Next is, if that person is of unsound mind, if the person is undischarged insolvent, if there is a pending insolvency application, then also he cannot become a director, people. Next is, he is convicted plus imprisoned for a period of at least 6 months and 5 years after the completion of his term of imprisonment has not completed, still he is disqualified. The moment I am convicted for an offense which is punishable for more than 6 months in 2025, that means what? I should wait till my imprisonment ends. Let's say my imprisonment ended on 2026. Then I cannot be a director for 5 years from the date of 2026. Yes or no, people? Next is, if I have been sentenced for a imprisonment for more than 7 years, then no matter how many years have elapsed after my imprisonment ends, I cannot ever become a director in any company. Okay. Now, if court or tribunal has disqualified, let's say NCLT has disqualified Vijay Mallya from acting as a director, in that case also he is disqualified even if the case is pending in NCLT. Next is, if the director has not paid calls on shares for a period of at least 6 months or more, in that case also he cannot be a director in a company. Yes or no, people? So if I am a director in a company and I myself have not paid the calls on unpaid shares for a period more than 6 months and still it is unpaid, if a company's director is only doing mistakes, how can I be appointed as a director in any company? It is 164 disqualification. If I am involved in any related party transaction offenses in the last 5 years, I cannot be appointed as a director. Okay. Next is, the company has defaulted. Let's see. Now a director is disqualified for 5 years for the mistake done by the company. Sir, what are the mistakes? Mistakes is if the company has not filed financial statements or annual returns for 3 consecutive financial years, then the company in which I was a director in, the director cannot become a director in any company. The company has not filed annual financial statements or annual returns for 3 years consecutively, the company's directors are disqualified to act as a director. Okay. If the company has not repaid interest, debentures, deposits for a period of 1 year or more, then the company's directors are disqualified. And next is people, now supposing company has done all these mistakes and I have been appointed as a director in that company. Now I have got 6 months to make sure to rectify all the defaults of the company. If 6 months have elapsed and still I have done nothing in the company, then automatically I will be disqualified to act as a director in companies. Which means what? I have got 6 months period to rectify the default. If I couldn't rectify the default in 6 months, I have to immediately leave the company, otherwise I will also be disqualified. Yes or no, people? This rule is made to make sure the defaults are rectified by at least the upcoming directors. Next is people, private companies can add additional disqualification apart from the Companies Act to make it more stricter. So we are done with this, people. Section 164 talks about disqualification of appointment of directors. Okay. Now, vacation of office of a director. When will the office of a director be vacated? Disqualification talks about if I want to be director in any other company, I cannot be appointed because I am disqualified. Now, during my directorship tenure, when will my office be vacated? When will I have to leave the company? Let's understand. Circumstances leading to vacation of office. Office of a director shall become vacant by removal of a director if I have been removed from the directorship. Yes or no? Next is if I incur disqualification of section 164. People, this is very, very important. Look at it. Applies to all companies except the one in default. What is the meaning of this? The moment I am disqualified, I have to vacate my office from all the companies except the one company in which I have defaulted. Can you tell me why I should act as a director? Why am I allowed to act as a director in this company and not all the companies? The reason is I should make sure that whatever mess I have created, I have to rectify that mess. For that purpose only, I am allowed to act as a director in this company. Yes or no, people? Okay. Next is people, if I have been absent from all the board meetings for 12 months with or without giving permission, with or without obtaining permission from the company, if I am absent for 12 months continuous, if I have not attended a single board meeting, then my office will be vacated. My office will be vacated. Okay. Next is people, conflicting of interest. If I enter into any contract or arrangement directly or indirectly in which I am interested in, it is contravention of law. It is contravention of law. The director should not participate in the meeting in which the company is entering into contract with a person in which the director is interested. If a company is entering into a transaction with my brother's company, I have to inform the company immediately that he is my brother. So whatever I might tell will be in favor of my brother. If I don't tell, it will be a wrong against the company. Yes or no, people? For that purpose, I have to disclose my interest upfront. If I don't disclose, my office should be vacated. Next is failure to disclose interest. I'll be held liable under section 184. Next is, so people, if I am a director in a company, if I am a director of company called as Alphabet, okay, because I was a director in Alphabet, I am also a director in Google. Because I was a director in Alphabet, for that reason only I am a director in Google. The moment my office is vacated from Alphabet, my office will automatically be vacated in the Google also. Yes or no? So same thing. If the directorship ceases to hold such office, director is appointed to holding office or employment in holding subsidiary associate, plus he ceases to hold office in these companies, automatically my office will be vacated, because I am a director in Google just because I was a director in Alphabet. So the moment my office will be vacated from Alphabet, my office will also be automatically vacated in Google also. Yes or no, people? Perfect. Now let's talk about these special provisions. So filing requirement, I have to file, company has to file DIR 12. DIR 12 talks about appointment, resignation of director. Next is, this is very, very important, people. If by chance, if all the directors of the company, if all the directors' office is vacated in a company, then who is going to be a director? In that case, promoter will appoint a director. Promoters will appoint a director. If promoters are not able to appoint a director, central government will appoint a director. Until which period? Until annual general meeting of the shareholders. Yes or no? The moment all the directors' office is vacated because of some fraud, because of some mistake, so people, in that case, promoter will appoint a director. If promoter fail to appoint a director, then central government will appoint a director. Until the annual general meeting, I will hold my position as a director in that company. Okay. Next is, people, private companies can provide additional grounds for vacation of office, and if the company does not follow these provisions, penalty will be 1 lakh to 5 lakh rupees. Okay. So this is done. Court, tribunal disqualification. People, now listen to me very, very carefully. This is very, very important. So we already know this. Court or tribunal has disqualified me from acting as a director. My office shall be vacated. Okay. Listen to me very, very carefully. If I am convicted of any offense for a imprisonment of more than 6 months, I have to vacate my office. Now, in these two cases, 5 and 6, my office will not be immediately vacated. The reason is, if I have filed an appeal in the tribunal, if I have filed an appeal against the order that has ordered me to be imprisoned, that means what? I am proving that I am not guilty. Yes or no? If I am proving that I am not guilty, my office should not be vacated. Now let's understand the provision with respect to this. So the moment NCLT tribunal has ordered me conviction of more than 6 months, or they have imprisoned me, and within 30 days of the order, if I appeal in the tribunal, my office continues until which period? Until 7 days after the appeal is disposed. After an order, after tribunal decides on the matter of appeal, I have got 7 more days. Until that period, I will hold my position as a director. Now people, the tribunal in the appeal has again told the same thing, that I am convicted, I am proven guilty. Still I can hold the office of director. Sir, what is this? Again, if I further file an appeal within 7 days, I can still hold the position of a director until the appeal is disposed of. The reason is, if somebody has filed a fake complaint against me, yes or no? If somebody has filed a fake complaint against me, that should not stop me from acting as a director, right? If I appeal, that means what? I am proving that I am not guilty. If I don't appeal, that means I am proving I am guilty. My office will automatically be vacated. Very, very easy, people. Okay. Next, let's talk about resignation of director. Resignation of director. What is the section of resignation of director? Section 168. So people, what is the standard process of resignation? So director gives a written notice stating the reasons why I have resigned to the company. Yes or no? Now, the board acknowledges that yes, you have filed a resignation. We accept your resignation. So number 1 is resignation letter. Number 2 is acknowledgement. Number 3 is the company has to intimate the ROC by filing which form? DIR 12, and post this on company's website if at all company has got its website. Okay. Now next, company also has to disclose this in the board report. Yes or no, people? And director, now what is the responsibility of director? Director has to file which form? DIR 11 with the ROC within how many days? Within 30 days of his resignation. It should be filed by director. Company has to file DIR 12. Director has to file DIR 11. Now, what is the effective date of resignation the moment he has resigned? So, what is the effective date of resignation? The date on which the company has received the notice of his resignation, or the date mentioned in the resignation notice itself, whichever is later. Yes or no, people? Okay. Now, special situations. If all the directors resign simultaneously, we all know central government will approve, the central government or the promoter will appoint a directors until the annual general meeting where shareholders will appoint. Next is directors will be held liable for the offences. Sir, but he has resigned. He will be held responsible for the offences that was done during his tenure, not after his tenure. Yes or no, people? Very easy. Now let's come to next topic, that is removal of director. Section 168 talks about resignation of director. Section 167 talks about vacation of director. Section 166 talks about duties of director. Section 165 talks about limit on number of directorship position. 164 talks about disqualification of director. 163 talks about proportionate representation. Okay. Now let's talk about section 169, and that is removal of director. So, general rule is that any director can be removed. Any director can be removed except if the director is appointed by NCLT. Except him, all the directors can be removed by passing ordinary resolution, irrespective of how he is appointed, including nominee director can be removed by ordinary resolution. So, if independent director has been reappointed for the second term, if independent director has been reappointed for the second term, to remove him from the directorship, special resolution is required. Special resolution is required. Yes or no, people? Special resolution is required to remove a director who is independent, who is holding his tenure for the second term. The reason is, if independent director who is not associated with the company at all, but who is holding his position for such a long period of time, and if company removes an independent director who is holding his position for such a long period of time, if company removes him, that means something wrong is going on. In that case, special resolution is required. Okay. So he must be given opportunity of being heard. People, now this is very, very important. Removal provisions will not apply if 2/3 of the total directors are appointed by proportionate shareholders. What is the meaning of this? So if there are 100 shareholders, okay, now we are giving 10 shareholders, we are giving the shareholders, let's say we are giving shareholders holding let's say 20% of the company. We are giving the shareholders who are holding 20% of the company to appoint 2/3 of directors. Yes or no? So these 2/3 of directors can never be removed by ordinary resolution or special resolution. Only proportionate representation shareholders can only remove them. Simple example. Supposing if I start a company called as ABC Limited and I have taken investment from Elon Musk, Mark Zuckerberg. So these people are holding 20% shares in my company, but in return, I give them the power to appoint 2/3 of the total number of directors, because they know that I cannot manage my company very well. They know the directors who are appointed by these people, they can manage the company very well. So these people only have the power to remove the directors. We will not have the power to remove the director. Very easy, people. Now let's talk about removal by NCLT. So if there is something operation mismanagement going on in a company, the company is conducting affairs in a fraudulent manner, in that case tribunal can remove the director after proper proceedings. Okay. Next is, so if a company wants to remove a director, what is the procedure? Number one is special notice. members will give a special notice proposing the removal of, let's say Elon Musk is a director, I want to remove Elon Musk as a director, I have to give a special notice to the company. Now I also have to inform Elon Musk by giving a copy of notice that I want to remove you. These are the reasons. Also, the copy has to be sent to the board of directors. Okay. Now, the board resolution calls for the removal. Board resolution is passed to remove the director. Next is, then what people, the notice, then we have to call the shareholders meeting, yes or no, the notice of the meeting, then special notice that we want to remove Elon Musk by passing OR. OR means ordinary resolution, and include directors representative if any. If I want to give Elon Musk the right to be heard, if I want to give power, if I am giving opportunity to Elon Musk that you can say your side of story, then I can allow him. Yes or no? So number one, I have to give a special notice to the company proposing to remove Elon Musk. Number two, I have to send the copy to the Elon Musk. Number three, I have to pass a board resolution to remove Elon Musk. Plus, I have to call general meeting by giving a notice, special notice to shareholders, plus informing them that we propose to remove Elon Musk by passing ordinary resolution. Okay. Next is, I should give opportunity to being heard to Elon Musk. Next is, if a company is a listed company, I have to inform stock exchanges, plus also forward the proceedings post resolution of the general meeting. Then people, I have to pass OR in the general meeting. Then I have to file with the ROC DAD 12 that we want to remove Elon Musk from the company. Plus we must attach the cessation proof, that is resignation letter. And next is interest details. And last is, I have to update the register and I have to give public notice if at all applicable. Okay people, very easy. Next, now that director's concept is done, now let's talk about managerial remuneration. Okay, managerial remuneration. What is section of managerial remuneration? Section 197. Okay, so what is the overall maximum remuneration that I can pay to directors? It is maximum 11% of the net profits. It is maximum 11% of the net profits. Now can I increase this remuneration of the director? Can I increase the remuneration of my managers? Yes, by passing a special resolution. By passing a special resolution. Okay. So, to which companies section 197 is applicable? To only public companies section 197 is applicable. Okay. So 11% of what, sir? 11% of net profit. 11% of net profit. Sir, what is net profit? Net profit is a way to calculate the net profit in which method? By following section 198. Section 198 talks about which all items you have to include, which all items you have to exclude while you calculate the net profit. Notional gains, revaluation gains, all the paper money should be excluded. All the paper money should be excluded and certain items should be included. Okay people. So section 198 tells you how to calculate net profit. So once we calculate net profit as per section 198, we have to find out the 11% of the net profit, which is what is the maximum remuneration that can be paid. The maximum remuneration that can be paid to whole-time director, manager, executive director. So these type of directors we can pay maximum remuneration. Okay. Next is people, this is very important. Okay, we know that overall maximum remuneration, how much can I pay? 11% of net profit I can pay to all the people, MD, whole-time director, manager. Okay people, now if I want to pay remuneration to only one MD, then what is the limit? If I want to pay remuneration to only one MD or one manager or one whole-time director, the maximum limit is 5%. If at all there are more than one managing director, if at all there are more than one manager, if at all there are more than one whole-time director, maximum how much can I pay? 10% of the net profit I can pay together. Yes or no? If it is individual, 5% together. If I want to pay, it is 10%. Okay. If I want to pay remuneration to non-executive director. Now there are two scenarios. If whole-time director, managing director exist, then how much remuneration I can pay to the non-executive directors? It is maximum 1%. Now, if there are no whole-time director, if there are no managing director, then maximum what is the remuneration I can pay? It is 3%. Okay, let's again revise. So maximum, how much remuneration can you pay to everyone? It is 11% of the net profit. Net profit is calculated as per section 198. Okay, so to one MD, whole-time director or one manager, how much maximum remuneration I can pay? It is 5%. If there are more than one MD, if there are more than one whole-time director, if there are more than one manager, maximum I can pay as 10%. Okay, if I want to pay remuneration to non-executive director, how much can I pay? If whole-time director, MD exist, then 1%. If they don't exist, I can pay 3% to non-executive directors. Okay. Now, if at all I have defaulted in the payment to the creditors, if I want to exceed the limit, I have to take their approval before I pay them remuneration. Okay. Mode of payment. Payment can be in monthly, payment can be percentage of the net profit, or it can be both. In case the company has no profit, in case the company has got inadequate profit, they have to follow Schedule 5 limits. Okay, people. So in your module, Schedule 5 limits is not there. So I'll just briefly tell you. If the company's capital, is negative to 5 CR, maximum remuneration I can pay to whole-time director, manager and MD, it is 60 lakh rupees per year. If it is other directors like non-executive or independent, it is 12 lakhs. If the capital is 5 CR to 100 CR, maximum how much I can pay as remuneration to managerial personnel, it is 84 lakhs. For other directors like non-executive independent, it is 17 lakhs, and so on is the limit. Let's look at last limit. If the capital is more than 250 CR, then I can pay maximum as 120 lakhs to the managerial personnel plus 0.01% of the excess of more than 250 CR. If capital is 300 CR, I can pay as 120 lakhs plus 0.01 of 300 minus 250, that is 50. Right, people? So again, sir, can this limit be doubled? Yes, by passing a special resolution. Okay. Next is mode of payment is done. Now, sir, what if we paid excess remuneration without the consent of shareholders? In that case, that director must refund me the money within how many years? Within 2 years. Shareholders can add another rule that this director has to return the money for a period less than 2 years also. Okay. Now next is until refunded. Can the director use this money to enjoy his life? No. It should be kept in a form of a trust. Next is, can the shareholders waive the refund? Can the shareholders give permission to directors that you keep this money, we don't want? Yes, by passing a special resolution within how many years? Within 2 years. And in case the company has defaulted with the banks or financial institutions, they have to take bank or financial institutions approval to waive the refund. Yes or no, people? So, and then last is the limits that we have spoken about: 11%, 5%, 1%, 3%. This limit will exclude 2 types of remuneration, which means what? If I am paying 100 rupees overall and 2 rupees I have paid sitting fees and 2 rupees I have paid in professional capacity, then the remuneration will be 96 rupees only. Yes or no, people? This type of remuneration will be excluded from calculation, which means what? Company can pay money in excess of the limits if it is in a form of sitting fees, and sitting fees can be maximum of 1 lakh per meeting, or if excess is because he is offering his services as a professional capacity, it is completely allowed. Sir, what is professional capacity? if he is providing some other services to the company, professional services, then that's completely allowed. Yes or no, people? And if the director is offering services in a professional capacity, you should make sure that he has got no interest directly or indirectly with the company, its holding company, its subsidiary company. Plus, he should not be related to the promoter as well as director. Plus, he should have some graduate qualification to call him a professional person. Yes or no, people? Perfect. Next, let's talk about what is the managerial remuneration. Okay, this is done already. Okay. Now, people, disclosure of remuneration. Company must disclose the remuneration that they are paying to directors. What is the purpose, sir? So that shareholders must know that how much of their money is going to the pockets of the management. Yes or no? So it is mandatory for listed companies. Which disclosure is required? Ratio of each director's pay to median employee pay. Median means middle value. Okay. What is the percentage of increase in pay of each director, CEO, CFO or CS, and what is their median employee pay? Then number of permanent employees, then comparison between employee pay rise with respect to managerial pay rise. Justify if we want to, we have to differentiate. If there's any differentiation, we have to justify why is there a differentiation. Next is we have to affirm, board has to affirm that whatever money we are paying, it is as per the remuneration policy only. Yes or no? We are not paying exorbitant money to the directors. It is properly calculated as per the remuneration policy. Okay. Now let's talk about other disclosures. Company has to disclose a statement of top 10 employees. Top 10 employees, what is meaning? Top 10 highest paid employees, number 1, or those employees who are receiving remuneration for more than or equal to 1.02 crores per year, or if a person is not appointed for a financial year complete, but he has been receiving 8.5 lakhs a month for a part of a year, it should be disclosed. It should be disclosed. Or if that person is earning more than managing director, holding director or manager, plus he's also holding 2%, more than 2% of shares in the company, then that person's remuneration should also be disclosed. Now, details should be name, destination of the employee, pay, his experience, and his etc. All the related details we have to mention. Now, compensation for loss of office. So, if a director's office is vacated, are we going to pay him money for the remaining term, or what is the procedure? In which cases we can pay him remuneration, in which cases we cannot pay him remuneration when he has been vacated or disqualified? Let's see. So first of all, in case we are paying him compensation, what is the maximum allowed? His remaining terms pay if he is appointed as a director for 1 year. If 6 months, after 6 months his office is vacated, for remaining 6 months we have to pay, or 3 years pay, whichever is shorter, that remuneration should be paid. Exception is the company has been wound up within the last 12 months. In that case, no compensation is allowed because that money now belongs to the stakeholders. Yes or no? Perfect. So, other services can include professional fees. Now, this is very, very important, people. In which scenarios compensation for loss of office is not allowed? Number 1 is if that director has been reappointed after amalgamation. If Vodafone and Idea has been merged, the director in Vodafone has ceased to hold office as a director in Vodafone, but he has been appointed as a director in Idea. In that case, would he be entitled to the loss of office compensation from Vodafone? No, because he has got a better position. Yes or no? In that case, it is not allowed. Number 2 is if he has voluntarily resigned from the company, it is not allowed. Number 3 is if tribunal has removed him, if he has incurred in disqualification, in that case, director cannot be given compensation for loss of office. And next is if the director was asked to resign from the company because of his own negligence or default, in that case, no compensation is allowed. And next is if he is guilty of any fraud or misconduct, or he has caused his own removal. Basically, if it is director's fault, company is not entitled to give him loss of compensation. Yes or no, people? Compensation for loss of office. Very easy. Now next is if the director has benefited under any role because of the company. If the director has received any money because he was a director in that company, he has to repay back the benefits to the company back. Yes or no? Very easy. Okay. Now let's talk about section 179. After that we will come to 180 and then 184 and then 188. That's the people. Then we are done. Okay. Now let's talk about section 179. Powers of the board. Okay. So what is section 179 trying to tell us? So board can exercise all the powers of the company that has been mentioned in the Companies Act 2013. The powers has been mentioned in the Memorandum of Association, Articles of Association. The powers are given by the shareholders in their general meeting. Yes or no? Okay. Shareholders can impose restrictions or conditions on the powers of the board. Okay. Now this is very, very important, people. If Companies Act allows a director to borrow money within the limits that does not require shareholders resolution. If the director has borrowed money, okay, after that shareholders have passed a resolution that this director shall not be allowed to borrow money. In that case, it doesn't mean that director's past decisions will be invalid. No, because it was as per the Companies Act, he followed it. After that, you have put in restrictions. From now onwards only, the restrictions will be followed. Before that, retrospective restrictions will not be allowed. Okay. So, any regulation passed by the shareholders cannot invalidate the acts already validly done by the board. Okay. Now, what are the powers that can be exercised in the board meetings? Let's understand. Number one is people making political contribution. Number two, asking for calls on the shareholders. Next is appointment or removal of KMP. Next is granting of loan guarantee security within the limits, obviously. Then people authorizing buyback under section 68. Next is issuing securities including debentures, whether domestic or foreign, that those powers are also conferred to the board. Next is borrowing money, approving financial statements and board report, diversifying the business, investing the funds of the company, approve amalgamation, merger, reconstruction, takeover or acquire controlling or substantial stake in another company, and last is appointing internal auditor or secretary auditor. To use these powers, shareholders approval is not required. Directors have been given by the Companies Act these powers. Okay. Now exception is section 8 company and IVS company. Powers to borrow, invest and grant loan can also be done via circular resolution. That is completely allowed. Circular means what? Physical board meeting is not required in case of IFEs and section company. Okay. Now people, this is very, very important. So board of directors can delegate their powers. Board of directors can delegate their powers to any committee of directors like CSR committee, NRC committee, audit committee. We understood, people. Next is can delegate the powers to MD or manager or any principal or officer of the company or any principal officer of the branch. In case if it's a branch office, directors can delegate these powers. Now people, what are the delegable powers? Borrowing money are delegable. Then investing company's fund can be delegated. Next is granting loans, giving securities or providing loans. For providing loans, it is completely allowed. these are delegable powers. Otherwise, other powers are non-delegable. Now comes the most important thing. Whatever delegation you are giving, if I am giving the audit committee the power to do something, now the meeting in which I am giving that power, that meeting should not be done via circular resolution. That meeting should be conducted by passing a physical board meeting. If I am, people, we know, first of all, we know the powers of the board. We know from where the powers came. Yes or no? We know what are the delegable powers. Okay. Now, when we are delegating the powers, the meeting in which we are delegating the powers, that meeting should be done in physical board meeting. That meeting should not be carried out in circular resolution where physical board meeting is not carried out. Very, very important, people. So we are done with section 179. Now here comes the exceptions. Banking company exceptions. Obviously, people, banking companies are involved in the business of accepting of deposits or inter-bank placements, which will not be called as borrowing or loaning. So borrowings by bank from other banks, again it is exempted. Arrangements are also exempted. So if company's ordinary business itself doing the things that will require shareholders approval, in that case it will not require shareholders approval, because your ordinary business is that only. You cannot go and obtain the shareholders approval again and again. Yes or no? Very easy, people. Section 179 talks about powers of the board. 164 talks about disqualification director. 165 talks about limits on directorship. 166 talks about duties of director. 167 talks about vacation of office of director. 168 talks about resignation of director. 169 talks about removal of director. Very easy, people. Okay. Now comes section 180. Section 180. That is restriction on board powers. Section 180 talks about restrictions on board powers. People, we know the powers of the board. Now we are going to understand the restrictions on powers of the board, the decisions, the powers that will require the approval of shareholders. Yes or no, people? So meaning is, board cannot exercise certain powers without the prior approval of the shareholders via special resolution. Board don't have unlimited powers. They have got limited powers, beyond which it will require shareholders approval. Now, which are those decisions that will require shareholders approval? If there is a sale, lease, disposal of undertaking, whether whole or substantially the whole. What is the meaning of undertaking? Undertaking means any business or project where more than 20% of the company's net worth is the investment, or that undertaking, project or business generates more than 20% of the total income of the company. In that case, it is called as undertaking. If the undertaking's net worth, if the undertaking's investment is more than 20% of net worth in the company, that means it's a very, very important undertaking. If the undertaking generates more than 20% of the total income of the company, it is called as undertaking. So, undertaking means any business or project that complies with two conditions: net worth and total income. This is a very, very important asset, people. If the directors are allowed to sell these things without shareholders approval, don't you think it's going to be wrong against the shareholders? Yes or no, people? Yes. So number one is sale, lease, disposal of undertakings, the whole or substantially the whole. Next is invest in the compensation received from merger or amalgamation. It will require shareholders approval. So people, if a company is investing, the company is, if, because people, do you remember, people, when I have taught you HUL and GSK's takeover? HUL and GSK, the moment HUL acquired GSK's business, GSK received money. Yes or no? Now with this money, how are they going to invest? That will require shareholders approval. That will require shareholders approval. So any type of corporate restructuring, including merger, amalgamation, if money is received by the company, how are they going to utilize this money? This will be decided by the shareholders via special resolution. Yes or no? Next is borrowing limits. Directors can borrow more than paid up capital, free reserves, securities premium, provided they are getting special resolution. Limits must be specified clearly via special resolution. Okay. So banking company, it is exempt if it is ordinary course of business. So 4 things we understood till now. Sale, lease, disposal of undertaking, whole or substantially the whole. Next is investing the compensation received from merger or amalgamation where shareholders approval is required. Next is borrowing limits. If board debtors want to borrow more than paid up capital, freezers, SP, it will require shareholders approval. Next is if the board of directors, if a director has taken a loan from the company, if a director has taken a loan of 10 crores from the company and the board of directors among themselves have given the permission to the director that you can pay, you can take your own time, you can pay after 10 years, you can pay after 5 years, you can pay after 6 years, or instead of 10 crores they are saying that you only have to pay 8 crores, that's completely fine. No, it is the money of the shareholders and not the money of the directors. So if a director is extension, if a director is granted remission or extension of a director's debt, giving him time or to remit payment of any debt, it will require permission from the shareholder via special resolution. Which means what? A director has taken a loan from the company. Now director, to give him the allowance to repay the money back after more than if he is given allowed extra time. If he was asked to pay instead of 10 crores, 8 crores, in that case, shareholders approval is required. Exception is very, very important. Good faith transaction, buyer or lessee. If a person has bought a property from a director and director has sold the property of the company to a person who has purchased in good faith, he did not know that the director he did not know, the buyer did not know the director does not have any power to sell the property. He has purchased in good faith. In that case, company will require the money from the director. Company will not go to the buyer at all. The property is gone. Yes, people. And if the sale and lease of property is the company's ordinary business, in that case, it is completely allowed, people. It is completely allowed. Okay. So company's ordinary business is itself buying and selling of assets. In that process only company has given to the directors. It is completely allowed. If it is not your ordinary course of business, you are not allowed. You will require shareholders approval via special resolution. Okay. So 179 is done. 180 is done. Now 3 more rules are there, people, then we are done. Okay, people. Chalo. People, the next chapters, certain topics I have also taken in this sub chapter, so that one time only you will be done. Okay. After you watch this lecture, 7 to 14 marks easily you can score in your CMA final law exam. Okay, people. Chalo. Restriction is done. Now 184. Disclosure by directors of their interest. Okay. So, disclosure of interest. What to disclose? If the director has shares in a company or entity, if he is having any concern or interest in a company, body corporate, firms or other association in which the company in which he is a director, if he has the shares of Myntra, if a director who's a director of Flipkart, if he has shares in Myntra, if Flipkart is dealing with Myntra, director has to disclose his interest, all the interest, if in entities in which entities means companies, body corporate, firms, or other associations. Now, when do you have to disclose? If a director who is a director in Flipkart and Flipkart is dealing with Myntra, the director has to disclose when that he has shares of Myntra. Number 1, at the first board meeting in which the director participates after he has been appointed. First board meeting in which he is participating after appointment. Number 2, first board meeting of every year he has to disclose. Next is wherever whenever any change in his previously disclosed interest, the disclosure should be made in the first board meeting after change. Basically, people, the moment you are holding shares in Myntra, the moment you acquire more shares in Myntra, the moment you sell some stake in Myntra, the moment you do anything with Myntra that is going to affect your biasness, immediately you have to disclose to the board of directors. When do you have to disclose? First board meeting of every year, first board meeting after you have been appointed, or whenever any change has occurred in your interest, you have to immediately disclose that to the board of directors, so that BOD will know that yes, you are holding shares in this company, so whatever you may say might be biased, so we will take that into consideration. If you don't say, and if you persuade, you convince the directors that yes, please enter in transaction with this Myntra, that means you are not acting in good faith. Yes or no? Perfect. So disclosure related to contracts or arrangements made or proposed with any body corporate, directors alone or with others, if he is holding more than 2% shares, or if he is the promoter, manager, CEO of that body corporate, or if he is a director, he has to disclose his interest immediately. Okay. Or if a company has entered into any contract or arrangement with a firm or other entity in which the director is a partner, owner, or the member, he has to immediately disclose his interest. Yes or no, people? So the moment company is entering into a contract or arrangement with a body corporate in which the director alone and with others is holding more than 2% of shares, or if he is a promoter, manager, or CEO of the body corporate, or if he is a director, immediately you have to make a disclosure. Yes or no, people? Now rules. Now what are the rules now you have to follow? Rules is disclosure must be made in the first meeting after where contract or arrangement is discussed. Interested director should not participate in the discussion or the voting. Number 3, director becomes interested post contract. During the contract, before contract, he did not have any interest. After contract, if you are interested, you have to disclose in the next board meeting. Okay. Next is, people, how should the director disclose the interest? In which form? In MBP 1, where it includes the shareholders' interest in those entities also. Yes or no, people? Exception is if you are holding minor shares in that company for a voting power of less than 2% shares, it is completely allowed. Okay, people. If Flipkart and Myntra is entering into a contract or arrangement and the director of Flipkart is holding 1% shares in Myntra, it is completely fine even if you do not disclose it. Right, people? So if you are not following this provision, director is liable to fine for 1 lakh rupees. Yes or no? Consequences of non-disclosure. So if you have not disclosed your interest and the company has entered into contract arrangement, you have participated. In that case, it is cancelable at the company's option. It is cancelable at the company's option. Very easy, people. That means what? If Flipkart has entered into contract with Myntra and the director has not disclosed any interest, in that case, the moment Flipkart knows that yes, this director was holding such amount of shares in Myntra, that's the reason why he was always saying in favor of Myntra only. In that case, the company believes that if we enter into this contract arrangement, it might be it might not be in favor of us, it might not be in our best interest. Immediately company can cancel the contract if they think it can be a bad investment. Yes or no, people? Perfect. Chalo. Now let's talk about section 188. People, another 15 minutes and then we'll be done with this sub chapter. Okay. After that, we'll be solving the questions, expected questions. Then we'll be solving past year question paper. Then you are done and dusted with this sub chapter. Okay, chalo. Let's read section 188. Section 188 talks about related party transaction. So what is the meaning? A company, if it is enter into a certain contract with related parties, it is called as related party transaction. If the company enters into contract or arrangement with related parties, it is called as related party transaction. Okay. Now what is the meaning of related party, people? Number one, related party in relation to the company. If I am Flipkart, who is my related party? Let's understand. If the director or relative of Flipkart is also director or relative of Myntra, in that case Myntra will be called as related party. Next is any body corporate whose board, MD or manager, any body corporate Myntra whose board, MD or manager acts as per the instructions or advice of a director in Flipkart, even though he is not holding shares, even though he is not a director, still these people are acting as per my advice. Again, it will be called as related party. Okay. Next is if the KMP or my relative, if I am a CS of Flipkart, if I or my brother is a KMP of Myntra, it will be called as a related party. Okay. Next is, now we are talking about the firm. So a firm in which director, manager or the relative is a partner. A firm in which the company's director, manager or my relative is a partner of that partnership firm, again that will be called as a related party. Next is, this is for firm. Again, this is for private company. Private company in which director, manager or my relative is a member or director in that private company, it will be called as a related party. Next is, firm is over, private company is over, now public company. People, over here it is different. Public company in which director or manager is a director plus is holding more than 2% of paid up share capital along with his relatives, it will be called as a related party. And the last is any body corporate including holding subsidiary, associate company of Flipkart or all the subsidiaries of the holding company. What is the meaning of this? Let's say Flipkart, this is Walmart. So Walmart owns one more company called as, let's say, Jabong. So Jabong and Flipkart are also called as a related party. The last is any investment company in which the company has invested in Flipkart or any venturer will be called as a related party. Now this is not applicable to private company. Okay. Now next, any person on whose advice, director or any advice or directions a director or manager is accustomed to act. Which means what? Over here, Myntra's directors are acting as per my instructions. Now over here, I am acting as per the instructions of somebody else, a person above me. Then we both will also be called as a related party. Exception is, people, if a person is advising me on professional capacity as a chartered accountant, cost accountant, company secretary, in that case we both will not be called as a related party. Yes or no, people? So that now we understand the meaning of related party transaction. When a company enters into contract arrangement with a related party, it is called as a related party transaction. Yes or no? Now we also understood the meaning of a related party. Okay. Now, transactions that requires the approval of the board, let's understand. So if there is a sale, purchase or supply of goods or material, it will require obviously board approval. Over here I'm not talking about any limits, okay? No limits at all. Number 2, selling, buying, disposing of property, it will again require the approval of the board. Next is appointment to any office or place of profit, which means what? I am appointing my nephew as a company secretary of my company, where the person should be paid actually 12 lakhs, but I am paying him 15 lakhs. Yes or no? I am paying him more. That means it's called as person holding office of profit. Next is underwriting subscription of securities. If I am promising a company that if public do not purchase shares, I will purchase your leftover shares. Again, it will require board approval. Next is leasing of property will require board approval. Every single thing is happening between related party. Okay, people. Next is availing or rendering of services between related party will require board approval. Next is appointment of any agent for sale or purchase is called as again related party. So over here, when board meeting is conducted, interested director in case of board meeting, interested shareholders in case of shareholders meeting cannot participate in the meeting. Shareholders can participate. When can they participate? If 90% shares are held by the promoter or the relative company is mine. So I can do anything with my company. Yes or no? If I am holding 90% or more as a promoter or my relative, I can participate in the meeting as a shareholder. But board director who is interested, he can never participate in the meeting. Now this is not applicable to two type of companies: private company, government company. Which means what? In private company, board can participate. Government company, board can participate. Okay. Now this is again very, very important. Over here, now I'm talking about the limits. What are the exceptions? Ordinary course of business, if the company's business itself doing the same thing, it will not require board approval, plus it is on arm's length price, it is fair price, it will not require board approval. So audit committee recommends what is arm's length price and board will accept it. Okay, and there's no audit committee, then board will only determine what is arm's length price. Okay, so now we understood which type of transaction will require board approval, which type of transaction will not require board approval. Ordinary course of business, arm's length price. Okay, we also know the meaning of related party. We also know the meaning of related party transaction. Okay, we also know when can directors participate. We also know when can directors cannot participate. Exceptions: private company, government company. We also know when can a shareholder cannot participate. We also know when can a shareholder can participate. 90% are held by the promoters or relatives. Okay. Now what are disclosures I have to make in the board report? So disclosure in the board report: contract, if it is entered plus not been approved by the BOD within 3 months, it is voidable at the option of the board or the shareholders. Which means what? Company has entered into a transaction with a related party. Board approval was not obtained. 3 months are over. Now the board has the option to cancel the contract. Shareholders have the power to cancel the contract if it required shareholders approval. Okay. Next is, if you have entered into transaction without approval, company can sue directors or employees for any loss that has been caused because of unauthorized contract. Yes or no? And last is, directors convicted for RPT, transaction offense, cannot be reappointed until 5 years. Cannot be reappointed until 5 years. Very important, people. Remember section 164, disqualification. Okay. People, now let's talk about when will shareholders approval be required in case a company enters into related party transaction. Okay. So again, same thing, people. Every single thing is same items, but over here limits are mentioned. So sale, purchase, supply of goods or materials, but the value is more than 10% of the total income of company, it will require shareholders approval. So appointment to any office or a place of profit where remuneration is more than 2.5 lakhs per month. I am appointing my nephew as a CS. I am paying him remuneration for more than 2.5 lakhs per month. Next is sale, buying, disposing of property for more than 10% of the total net worth of the company. Next is underwriting of subscription. It is remuneration or commission paid to underwriter is more than 1% of net worth. Next is leasing of property. Limit is 10% of turnover or 10% net worth, whichever is higher. Now remaining two items, availing or rendering of services, appointment of agent for sale and purchase. In that case, the limit is more than 10% of turnover. Yes or no, people? Now this is again exempt for government companies. Now comes the most important part. If the company's paid capital is 10 CR or more, if the company's paid capital is 10 CR or more, any RPT, even if it is below the limit, it will require shareholders approval. Now, this is not important, people. Just remember, when will shareholders approval be required? When will directors approval be required? When will directors approval is not required? In case director approval is not obtained, how much time does a company have to rectify and get approval? And what remedies the company have in case the director has not ratified within 3 months? In which scenario director can participate? In which scenarios shareholders can participate? In which scenarios shareholders cannot participate? Every single thing you should be thorough with, okay? Every single thing is mentioned in the mind map. Right, people? This is the power of mind map. Before exam, just go to this. Then you are sorted. Okay. So 184 is done. 180 is done. 188 is also done. Now 1, 2, 1, 2. 2 more mind map, then we are done, people. Okay. Chalo. Omnibus approval of RPT. What is meaning of omnibus? So people, audit committee may allow the company to enter into RPT. Now people, the company is continuously entering into RPT. Company is continuously entering into RPT. Now audit committee's approval, if continuously obtained, again and again obtained, if the company is entering into RPT for 1,000, 10,000 times a year within the limits, and it is not possible to get approval of audit committee every single time, right? So audit committee will give a blanket approval that we will give you this limit. Beyond this limit, you cannot cross transaction. Within this limit, you can enter into any number of transaction in a financial year, which will not, you don't have to come to us again and again for approval. We'll give you certain rules. You have to follow those certain rules. If you are not following, then you are at fault. You have to follow the rules. In that case, you will not require my approval. Now let's understand this. What is the meaning of this? When a company has frequent transactions with related parties, subsidiaries or promoters, audit committee can give single pre-approval for all similar transactions that are repetitive in nature. Instead of approving each one separate, they will give one small approval. They will give one approval that all certain types of transaction within the limits, you will not require our approval. Tenure is 1 year, we'll understand. Okay. Now, what are the key details to be included in the omnibus approval? Name of the parties involved for which you are giving such approval. Next is name and duration of the transaction. What is the transaction duration? Maximum transaction amount allowed. Then people, indicative base price. What is the market price and what is the contracted price? Next is other relevant information. And what is the formula when you have arrived at the price in which you are dealing with the RPT? If audit committee gives all these rules, company don't have to take approval of audit committee again and again. Okay. If transactions cannot be foreseen or details cannot be foreseen, in that case approval can still be given provided the value is less than 1 CR per transaction. A value should be maximum 1 CR per transaction. Okay. Now validity and renewal. What is the validity of this permission? Valid for 1 financial year only. Fresh approval is required in the next financial year. Yes or no, people? And restrictions. Omnibus approval is not granted for selling companies' undertakings to the RPT. We all know this. Audit committee can add other conditions as it deems fit. Now, what are factors will audit committee consider before giving a blanket approval? Number one is, what is the repetitiveness of the transaction in the past and the future? The transaction is not repetitive in nature, they will not give you approval. Next is justification. Why is omnibus approval required? Are we going to wait? Are we going to waste a lot of our time if we give you approval, or if not, you are not? Okay, I will again tell you. If we are willing to give you approval and we are not being inefficient, then we cannot give you omnibus approval. If again you are coming to us for omnibus approval, then we can give you omnibus approval. So justification for omnibus approval, whether required or not, in the company's best interest. Yes or no? So what is the meaning of omnibus approval? Company, if it is entering into related party transaction, continuously approval of audit committee, if it is in repeated nature, is not possible. In that case, audit committee will give certain rules that you have to follow. You have to follow these rules, and if you are following these rules, you don't have to take our approval. And this rule is only valid for 1 financial year. Very easy. Now next, last. Appointment of key managerial personnel, section 203. Okay, so which companies are required to appoint KMP? Every listed company and every public company having a paid up capital of 10 crore or more, they have to appoint KMP. Now, what is the meaning of KMP? KMP means MD, CEO, manager, or if none are appointed, whole time director. CS should also be appointed. CFO should also be appointed. So MD, if no MD, CEO, if no CEO, managing manager, if none of the 3 people are appointed, then whole time director, they should be appointed. After that, CS should be appointed and CFO should be appointed. Now, this is rule 8 of the company's appointment and remuneration of managerial personnel says. Now, what is rule 8A says? If every private company whose paid up capital is 10 crore or more, they have to appoint CS, whole time CS. Yes, people. So over here, chairman restriction. This is very, very important, people. Same person cannot be a chairman and MD or CEO or CFO. Chairman plus MD cannot be the same person. Chairman and CEO cannot be the same person. Chairman and CFO cannot be the same person. Now, why is this rule made, people? So that duties and responsibilities should be effectively distributed. If one person is handling everything, company might not perform efficiently. But there are exceptions to it. When a chairperson can be MD, a chairperson can be CEO, a chairperson can be CFO. What are the exceptions? If articles of association of company permits it, company has only one business. So for one business, it completely makes sense for me to hold MD, CEO, CFO and chairperson. If company has multiple business, do you think I can serve as a chairperson and MD, manager, CEO, MD, CEO, CFO? No. But if the company has got multiple business, it is not possible. But the company has got multiple business and CEO is there to manage the units. In that case, if somebody is there to take my responsibilities, in that case I can be the chairperson and MD, chairperson and CEO, chairperson and CFO. To supervise I can be. Right, people? So what the rule says? Chairperson cannot be MD, chairperson cannot be CEO, chairperson cannot be CFO. What are the exceptions if AA allows it? Number 2 is company is involved into only one business. The company has got multiple business and separate CEOs are there to handle multiple business. In that case, I can be chairperson and MD, CEO, CFO. Very easy. Now comes restriction on holding office. So a KMP can hold office only in one company. KMP can hold office only in one company. Exception is subsidiary company. If I am the KMP of Flipkart, I can also be a KMP of Myntra. Yes or no, people? Next is if I want to become, if I'm a KMP in one company, if I'm a CS or a CEO or a CFO of one company, if I want to become a director of another company, I have to take the board consent. I have to take the consent on the board that I am going to become the director of that company. Are you okay with it? And next is, this is for separate. This is for MD. Yes or no? If the KMP wants to become the MD or manager of another company, in that case, board approval, that is unanimous approval is required. 100% approval is required of the board, plus prior notice should be given to all the directors that I want to become the MD or manager of that company. So this is called as section 203. So we are done with the subchapter of appointment of debtors and KMP. Every single thing is done, people. Board of debtors and KMP. Now what we're going to do is, let's take 5 minutes break. Let's take 5 minutes break. After that, we're going to solve past year's question paper. Then expected question also we will solve quickly. Okay? Chalo. Yes, people, let's continue with our expected questions. People, I know this lecture has been little lengthy, people, I know, but trust me, you're going to make a lot just by watching this lecture. You're going to get beautiful marks after you are done with my lectures, people, because every single thing I have covered. Okay, so without wasting any time, people, I will not talk more. I will not take a lot of your time. So quickly, I will complete up with the expected question and we'll see past year's questions also. Chalo. People see, I've also given you the notes for this. Okay. Now, people, you have to answer me this question, okay? In compliance with companies, and at least one woman director shall be on the board of such class or class of companies as may prescribed. Ria is keen to hold the office of a woman director in a company. She has selected some companies in which there is a vacancy for woman director. Guide Ria in selecting the companies which are mandatorily required to appoint woman director as per company's head. Also explain as to when a company is required to appoint a woman director. People, number one, tell me the applicable woman director. Paid up capital should be 100 CR or more. Turnover should be 300 CR or more. Yes or no? Paid up capital is 100 CR. Turnover is 100 CR. Every listed company should also appoint woman director irrespective of their paid up or turnover. So these two companies are supposed to appoint woman director. So Ria can become a woman director in this company. So what is the provision? Every company having a paid up capital of 100 CR or more, turnover should be 300 CR or more. Or not and, they have to appoint a woman director. Very easy. Listed companies, irrespective of paid up turnover, they have to appoint a woman director. Very easy. Chalo. Next question. Dim Dam Limited was incorporated on 31st December. An advisor to the company has suggested that since the AOA does not contain the provision with respect to appointment of first directors, the company cannot function without directors until AOA is amended. People have told you subscribers are deemed to become the first director. The first topic that we understood in today's lecture. So the moment company has not company does not have a first director, the subscribers are deemed to be appointed as the first director of the company. Okay. Now, can Dim Dam Limited appoint a director who has just stayed for a period of 120 days in India during a financial year? Okay. So people always remember 180 days is for the complete financial year. 180 days is for complete financial year. But the company was incorporated on 31st December. Yes or no? In mid of the financial year, company was incorporated. So does it make sense that December, okay, January, February, March. So for 3 months, he has to, even if he stays in India for continuous 3 days, continuous 3 months, still would he be able to fulfill the criteria? No. In that case, people, companies that has given you a exemption or a provision where it says that if for 12 months the requirement is 182 days, if for the complete financial year a director has to stay in India for a period of 182 days, if the company was incorporated on 31st December, how many months are there to complete the financial year? 31st December, January, February, March, 3 months. So you have to take the proportion. So 182 days into 3 upon 12. So something 45 days will come, right? So director has to stay in India for a period of 45 days. Yes or no? But he has stayed in India for a period of 120 days. So that means he has complied with the condition. Always remember the 182 days is for the complete financial year. If the company was incorporated during the financial year, in the mid of the financial year, so 180 days will not be applicable there. Proportionately, days will be counted. Remaining, how many months are there to complete the financial year? That month will be calculated for cross multiply. Simple cross multiply, very easy. Okay. Now next, Shankar was appointed as a small shareholders director on 2nd March. Shankar has submitted a letter to the board of directors expressing his desire to be reappointed. Can a small shareholder be reappointed? The answer is no, people. So he cannot be reappointed. Whether is he liable to retire by rotation? Again, the answer is no. Independent and SSD. SSD means small shareholder director are not liable to retire by rotation. Since Shankar is serving as director in many companies, whether his directorship in the capacity of small shareholder will be included in the total number of directors as per provisions? No. Okay. People, once again. Let's read the question again. Since Shankar is serving as a director in many companies, whether his directorship in the capacity of small shareholder director is be included in the total number of directors? Yes, people. People, do you remember? Maximum a small shareholder can be a director in how many companies as small shareholder director? In maximum 2 companies. Okay. Next, the 4 board meetings were held during July to December in a calendar year 23. So July to December is 6 months. July, August, September, October, November, December. 7 months. Thunder, a director, attended none of them. For the first 3 meetings, he sought leave of absence from the board, but did not inform the board regarding the last meeting as he was hospitalized. In the light of the provisions, examine if he is disqualified to act as a director. People, we already know if a director is not attending the board meeting for 12 continuous months, in that case, irrespective of whether he sought leave of absence or not, he will be disqualified. His office will be vacated. But is July to December 12 months? No, people. So he will not. His office will not be vacated. Very easy. Akshay for going abroad for 6 months appointed Raghav as a director in his place during his business from India. So Akshay has appointed an alternate director because he was out of India for 6 months. First sentence itself is saying that it is not allowed. Does a director has the power to appoint an alternate director in his place? No. The BOD has the power. Yes or no, people? The board, rejecting the appointment of Raghav, appointed Madhuri as an alternate director to Akshay. Explain the relevant provision, assess the validity of appointment of Raghav and Madhuri under the provisions of Companies Act. Also state the tenure for which alternate director is appointed. We know, people, tenure, every single thing is covered in the alternate director's mind map. Yes or no, people? His tenure will be of the original director's tenure. Number 1, if he returns to India, or if his office is vacated, his office will also be vacated. Yes or no, people? So that means the board rejecting the suggestion of Akshay and appointing some other person in his place is completely valid. Akshay does not have the right. Board has the right to appoint alternate director. Very easy, people. Next. Advise the BOD of Clean Limited on the following matters. Can Ram, who is already serving as a director, be appointed as the CEO or CFO of the same company? Can Ram be appointed as MD of Clean when Shyam is already functioning as the manager? People, you all know this. MD and manager can never be the same person. Company cannot have MD and manager at the same time. Yes or no, people? What is this question? Can Ram, who is already serving as a director, not MD, just a director, be appointed as a CEO? Yes, he can be appointed, but can an MD and a CEO be appointed at the same time? Answer is no, but there are exceptions. AOA, single business, multiple business, separate CEOs. Next is Amit, who has a vast experience in managing a steel manufacturing company for more than 20 years, holds an MBA from IIM Ahmedabad, is also a CA. PQR Private Limited, engaged in the steel manufacturing business, appointed Amit as a MD for lifetime. Can MD be appointed for lifetime? The answer is no. MD's tenure is, people, maximum it is 5 years. So articles of association of company provide for appointment of MD for lifetime. Examine in light of the provision whether such appointment is valid. Would your answer be different if it is government company in which he is appointed for the period till he retires? It is allowed, but over here it is not allowed. He is appointed for lifetime. How can you appoint any MD for lifetime? It is not allowed, people. That's it. Okay. This is again, people, very interesting question. The following information is given. Equity, share capital, preference. Okay. Always read the last question. What is the question? People, just 1 second. Question is, which companies are required to appoint whole time KMP? So we all know every listed company shall appoint. Every public company having a paid capital of 10 crore or more, they have to appoint. So paid capital is 10 crore or more, they have to appoint. Very easy, people. That's it. Okay. How many questions are there? One. Last question. Let's read this. Happy Healthcare Services Private Limited is one of the leading companies in the medical health. Let's read the last question directly. As a corporate governance expert, advise shareholders in light of the provisions of the Companies Act and other relevant provisions regarding the stat limits on remuneration of KMP. 11% people, 11% we know this. 1%, 3%, we all know this, people. 5%, 5% if there is one MD, and 10% if there is more than one MD. If we are paying to non-executive, if whole time director exists, 1%, otherwise it is 2% people. Sorry, 3% people, we know this. The requirement of shareholders and central government approval if applicable. Over the past years, the company has shown significant growth. Okay, shareholders have now raised concern about whether such remuneration is appropriate. So people, central government approval is then only required when the appointment is not as per Schedule 5. Schedule 5 puts basic conditions as to he should not be involved in fraud, he should not be a minor, such type of basic condition. If you are not following that, then central government's approval is required to make him as a KMP in the company. Very easy, people. So this is how questions can be asked in exam. Simply by getting thorough with the mind map, you will be sorted, people. You will be sorted. Now let's look at the past year's question paper. All RPT transactions require approval of audit committee, and the audit committee may make omnibus approval for RPT proposed to be entered. You have to write the entire mind map of the omnibus approval audit committee. Yes, people. See, for 7 marks questions were asked. Okay. See again, section 180 for the companies that provide certain restrictions and powers of the BOD. List of those restrictions. Direct question has been asked, people, simply for 7 marks. That's it, people. See, I told you 14 marks question will be asked. 14 marks questions were asked. This is of which paper? Which paper? It is December 23. Okay. Let's come to June 24. Okay. The BOD of McKinsey Limited listed company appointed Dinesh as an executive director at the board meeting held on June 1. The company took up his appointment of Dinesh for approval of the shareholders at its annual general meeting held on 29 September. But the same was not approved by the shareholders. So he was proposed to be appointed. Shareholders have denied his approval. However, he was appointed as an additional director on whole-time employment by the board at its meeting held on. Is this valid, people? If shareholders have already denied your approval for directorship in past, can you be appointed now as an additional director by board? No. By passing a resolution to hold office of directorship till the conclusion of the next AGM to be held on 24. Is appointment of Dinesh as an additional director be justified? You have to tell these people yes or no. What is the eligibility criteria for appointment of additional director? You can be appointed. Any person can be appointed except the one whose appointment has been denied by the shareholders in their meeting. Yes or no? See, 7 marks, simple question. People, 7 marks question was over here. Now let's look at the next paper. December 24. December 24. So people, next question. Mirinda Limited is an unlisted company with a paid capital of 40 CR or more. Again, appointment of KMP is required. It's a public company. Paid capital is 10 CR or more. The company has the following top management. Rajiv Mishra, who is a promoter and MD of a company. MD is allowed. Preetham is a non-executive. Okay. Anurag Sinha is a promoter. CS is supposed to be appointed. Okay. Now let's look at the provision. What is the provision says, people? Let's see. Every listed company, every public company with a paid capital 10 CR or more must appoint full-time KMP. What is the meaning of full-time KMP? They must appoint a CS, they must appoint a CFO, they must appoint an MD or a whole-time director. So MD is there, CS is there, CFO is not there, it's a non-compliance. The company is in plan for expansion, therefore wants to avail a sizable loan from Nationalist Bank. The bank wants to nominate a director in the board. MD seeks your advice in the following points. Is the present board properly constituted? If not, what is the non-compliance? CFO is not appointed, people. Number 1. Can Mr. Anurag Sinha be considered as an independent director? Where is Anurag Sinha? Anurag Sinha operation is related to promoter. He cannot be. Clearly question says it is related to promoter. Next is, what was the status of the director if nominated by bank? If the said nominated director is a woman, would she satisfy the requirement of a woman director? The answer is, people, yes, it will still be satisfied as a woman director. Remember, people, when I was teaching you how to answer questions, there was a slight confusion over here. So in the companies that nothing is mentioned about that a person nominated as a woman director should be different from a woman director requirement. Both can be the same person. Okay, people? So this is allowed. What is the status of a director nominated by a bank? So you know, nomination, every single thing is extremely clear to you. We know that nominator will enjoy his office until the nominating agency resigns. Nominating agency withdraws his directorship. Yes or no? So that person holds the directorship at the pleasure of the nominating agency. That's it, people. Is a requirement of a CFO? Obviously, there is a requirement of a CFO. You are required to MD. You are required to advise MD suitably. Very, very easy, people. That's it. Over here, people see, woman director is also required. Woman director is also required because turnover is more than 300 CR. So, your answer should be company as it crossed more than 300 CR turnover, they are supposed to appoint a woman director. Yes or no? Company has to also appoint a CFO because it has exceeded their threshold of paid capital of 10 CR or more. Number 2. Next is Anurag Sinha is related to promoter, so he cannot become an independent director. Number 3. Number 4. Woman director. If she is a if she is a director, if she is a nominator, it will be also calculated under woman director requirement. That's it. This should be answer, people. So see, 7 marks question was asked. Next, let's look at this question paper. This is of which paper? This is of June 25. June 25. State the responsibilities of an audit committee constituting a company. Is any recommendation of such committee binding on the board? People, this we are going to discuss in the next chapter. Okay. Briefly discuss about the impossibility, various exemption companies that false hard bottle. Yes, people. So in this attempt, no question was asked from that sub chapter. Yes, people. So we are done with today's lecture, people. Always keep in mind 7 to 14 marks weightage from this chapter can definitely come into exam. You just have to go through my mind maps, just revise using my notes. That's it, people. You are sorted. I've also given you expected question. I've also discussed the past year's paper. That's it. We are done and dusted. Okay. The next lecture we're going to cover all the small remaining chapters of the company law. Cool, people. So thank you so much for watching. You have been an amazing audience. I will see you in the next one. Until then, eat well, sleep well, study well. I will see you in the next one. Take care. Bye bye.